Floor is yours, Deborah.
Okay. Hey guys. Thanks for joining. Um, my name's Deb Grant. I'm an advocate with Disability Rights of West Virginia, and today we're going to talk about special education basics for helping professionals. Probably very, very few of you might know that I actually used to be a special ed teacher. I had 10 years in special ed at the beginning of my work career, and I get to wear that hat sometimes at DRWV, like today. I do have a couple places built in for questions, so if you want to chime in then that would be great, but otherwise we'll put some stuff in the chat and try to get to them. Although if you have something that like you need to know like right now, we'll yield for that. So we have some objectives. Our objectives today are to describe DRWV's role as a protection and advocacy organization for West Virginia, to explain the processes for a student to enter and receive special education services, and discuss some of the issues related to more vulnerable kids that helping professionals are likely to come into contact with or come into contact with their parents or their family. And so, just a note about the word parent. I'm going to use the word parent mostly because that's the language that we mostly use. But if you think about parent to include caregiver, guardian, pretty much any grown up who's like in charge of a kid, that's who a parent is for the purposes of this. So we always get to talk about Dear WV a little bit. Um, who are we? So we are Disability Rights of West Virginia is the federally mandated protection and advocacy organization for people with disabilities in West Virginia. Starting in the 70s and 80s, United States Congress has passed different pieces of legislation over time to ensure that the rights of people with disabilities are protected and respected, and that we're looking at things like community integration, least restrictive environment, and those sorts of things. Every state has to have one. We're it for West Virginia. We're a 501(c)(3). We're a private nonprofit. Services are free and confidential. So what do? We do a lot of different things to serve people with disabilities. Um, we provide lots of information and referrals. Pretty much anyone who contacts us is going to get mail from us with information in it. Let me change that. Any person who's an eligible potential client. We investigate abuse, neglect. We provide individual advocacy for specific issues, and that would be, we call that a service request, but that's like what most folks would call like a case um, to work. Um, we train professionals and natural supports on how to work with and on behalf of people with disabilities. So that's what we're doing today. We also really promote self-advocacy education and encourage folks with disabilities to do what they can do for themselves. And then we also engage in systemic advocacy, litigation, and legal representation. So, for example, Disability Rights is one of the organizations, agencies that brought the foster care case against the state. It used to be Jonathan R. versus Justice. Now it's Jonathan R. versus Morrissey. And you guys might have heard about that. So, all of our programs are grant funded. We have 9 federal grants and 1 state grant. The first 4 federal grants are disability driven, meaning that we act with and on behalf of individuals with disabilities on a variety of issues. Some of those are home and community-based services, abuse, neglect investigations, housing discrimination, rights restrictions, stuff like that. PAD was first. So all of these are all but one of them are PA and then something. And so that means protection and advocacy for whatever the thing is. So PAD is protection and advocacy for individuals with developmental disabilities. This includes folks with intellectual disabilities, cerebral palsy, Down syndrome, all of those types of things, Down syndrome, things like that. Next is PAMI, protection and advocacy for individuals with mental illness. That's actually the grant that I work under, and that's pretty self-explanatory. It includes just about anything in the DSM. So mood disorders, thought disorders, conduct disorders, or personality disorders, anxiety, trauma. The only thing that it doesn't, that we don't work with in as a primary diagnosis is substance use disorder, which is kind of funny because that's what we're doing here. However, usually when we talk with a person and they think that's their diagnosis, and then we talk some more, we usually find out that somewhere along the line they either had traumatic brain injury or they have a mental health diagnosis, and we're able to serve them that way. And then Pat B, traumatic brain injury, that's for serving people with traumatic brain injury. And then PAIR stands for Protection and Advocacy of Individual Rights. And this is for folks who have one area of disability that can't be served under someplace else. And this is mostly where we serve older West Virginians. Next, we have our issues-driven programs. And these are based on an issue. So some of these, again, kind of self-explanatory. Protection and advocacy for assistive technology focuses on assistive technology. Same with PAVA, it works on voting access. CAP and PABS kind of go together. They're both about people with disabilities who want to work, who want to begin working, improve their skills, advance in their careers. Those to work really closely with the West Virginia Division of Rehabilitation Services and Centers for Independent Living. The feds also, along with the P&As, they also, every state has to have a vocational rehabilitation organization, and that's in West Virginia is DRS. Every state has to have Centers for Independent Living, and those are usually called CILs. We do have a specific advocate who works on those CAP PABs service requests. She's really good with it. So for folks who want to get a job with or without receiving SSI or SSDI. So PABs is for folks who get SSI, SSDI. CAP is for folks who don't. Then the last one is our Rep Payee program. It's like secret squirrel. That is really highly confidential. They have their own printer, their own shredder. There's a lot of rules around what they're allowed to do and take home and take different places. And whereas the rest of the programs, we get our referrals from folks in West Virginia who contact us or someone lets us know about them. For Rep Payee, the Social Security Administration tells us who we're going to review that year. Last grant is the Medley Hartley Advocacy Program. They were both class action suits related to folks with IDD and institutionalization. And so to be eligible to be a Medley class member, a person has to be a resident of West Virginia, have an IDD diagnosis. They have to have spent more than 30 days in a state hospital, which today means either Sharp or Bateman. But in the olden days, there was a lot more. Weston State Hospital, which Sharp replaced. There was one in Greenbrier County. Colin Anderson was a really big one up in St. Mary's. So in one of those state hospitals, more than 30 days in a state hospital before turning 23. And the original decree had a date in it. I looked and could not find that date, but it's something really random like April 1st of 1952 or something that you have to be born after that date. That's pretty much a moot point at this time. But Medley class members, once they're certified down in Charleston, they have access to an advocate for life unless they move out of state or if they tell us that they don't want to work with us anymore, that's fine. If they change their mind in a year and a half and come back and say, hey, we'd really like advocacy again, that's also fine. We'll pick back up with them. So that is the end of the DRWV section. Do you guys have any questions about DRWV before we go on? Okay, great. So, the Parents Advocacy Guide to Special Education. This is the source for pretty much everything I'm going to tell you today. And it's already been approved by our funders. Everything has to be approved all the time. And so all the information in the PAG has already been approved. So I can share that with you. The PAG was developed by the West Virginia Developmental Disabilities Council and Disability Rights of West Virginia. And we're on our 4th printing. It was developed in response to parent requests to get instructions and materials to help them better understand special education. The guide references different federal and state laws and policies. And so some of those are IDEA, the West Virginia Department of Ed Policy 2419, which is like the special education Bible in West Virginia. And I am talking about West Virginia. Some of these things are going to carry over from state to state. Some of them are going to be state specific. And then also WVDE Policy 4373, which is expected behavior in safe and supportive schools. If a parent wants a copy of 2419, the State Department of Ed will provide that to them at no cost. I have a bit of a little disclaimer here. The Parents Advocacy Guide does not constitute legal advice. It's an advocacy tool. I am not an attorney. I cannot give you legal advice, and I wouldn't pretend to. One thing that's in the PAG that's really helpful, I think. I mean, this is an awesome resource. It is really helpful generally. You can get an actual copy. It's about yay thick, or you can look it up online on our website. But one of the things it does, it includes tips for parents in each of the different sections. There's, I think, 9 chapters, and there's tips throughout. Because I have a really bad tip, like I have a lot of words. And so since I use a lot of words, I tend to run out of time when I give a presentation. And so I wanted to get to some of the good stuff before we get to the end, just so that we can make sure that we get to cover it. So I wanted to share some tips to share with parents. And so the way that I kind of conceptualize this is I'm talking to you guys as helping professionals, and you're either working with the kid or you're working with a parent or some other grown up who's taking care of a kid. And so these are ideas that to share with parents when they're talking about, or whomever, when they're preparing for a meeting. So the first one is ask for prior written notice. So prior written notice is a form that the school has to do whenever they decide to do something or not do something. And it's a really important piece of paper. And so it's really important that whatever happens, to let the parent know that they want to get prior written notice and then keep that. That's another one here, put it in writing and keep records and teach them how. So keep putting things in writing. A date and time stamp on an electronic communication is fantastic. And then keeping all of those papers, and not every person's going to know how to do that. And not every person's going to be able to do that. If you think about families that we work with who have to move a lot, and if they get evicted and landlord locks up their apartment and they never get the stuff in their apartment back, they would lose those special education records, but they're going to need them over time. And so one suggestion that I had was to identify someone who is more stable, who lives in a place that they're probably going to live for a long time, maybe a family member or a close friend, who's willing, and that person has a good relationship with, who's willing to kind of be a space for those things to live and the parent to come back to if they're going to need those things down the road. Sometimes parents are not super comfortable about their own written language skills. That's okay. The Parents Advocacy Guide has some templates in there, and it literally has like everything like dear, name of person, address. Writing about put kid's name here, child who is in this grade at this school. So it really breaks it down for parents. Another really important thing is and maintain composure and building a good relationship. These two things go together. Just some information. We don't want parents to threaten to go to the Board of Education. The Board of Education has nothing to do with IEPs. They're like elected people who don't work for the school system. Don't threaten to sue. If a parent wants to file a complaint, they can do that. A good recommendation is if a person's thinking that they want to file a complaint, they want to get an attorney before they file, because it's hard to find an attorney to take special ed cases, and there's timelines on everything. And if you miss the timeline, then you miss the timeline, you kind of got to start over or whatever. And also, the attorney's going to want time to see what the case is and see if they think that they have a case. The school will always have a lawyer. There's a lot of power imbalance with these types of meetings, as there often is when parents meet with us. There's a lot of power imbalance, and that's part of that maintaining composure piece. But thinking about filing formal complaints, the school is always going to have an attorney. The family might want to as well. The other thing, another thing about that is schools, e- teachers are people too. They're not like teaching machines at school. They have, and everybody who works at the school have their own assumptions about who's who and what's what. And so when a family walks into the room, um, I would like to think they're not being judged, but I know from my experience that they are. So, like, this is completely random, but for example, people who smoke cigarettes do not realize how much they smell like smoke when they go around people who don't smell like cigarettes. Smoking cigarettes is no longer a thing to do in the world, and it's really likely that a person who goes in the wintertime when their winter coat reeks like cigarette smoke, and God forbid not weed smoke, the people in the school are going to notice that and they're going to have judgments about that. I mean, I'm sure some don't. I'm sure some that are perfectly mentally healthy and have acceptance for everything and all that happiness, but you know, um, really want to come in with a positive attitude, and the teachers might have bad feelings, might feel bad about themselves for not being able to handle the student or not be able to educate the student. So they're having some thoughts and feelings. The parent is really likely to have some thoughts or feelings about not being a good parent because their kid isn't being successful. And so having that in mind going in, and teachers don't know what they don't know. Like, I don't know at 50 something what I knew when I was a teacher at 30 something. There's lots of training out there, and teachers might just might not know yet. And so that's always a place to work towards, is offering, suggesting more training. Want to find something to agree on. There's got to be something good that happened that the school can agree on. They can agree on the kid likes football. They can agree on the kid did really well in the art unit about collage or whatever. Try to find something to agree on. Some word choices to share. Phrases like, could we try? Is it possible? What would it take to make something happen? Want to avoid you statements and overgeneralizations like the school always, the teacher never, and then trying to use the word we, because it's a team process. Um, Talked a little bit about record keeping for families who are involved with the department in some way, either through CPS or youth services. If they're working with a socially necessary services provider, that might be a good person to talk to the parent, work with the parent on keeping records and what those are and what those mean and how to do that, how to call the school, how to keep documentation or memorialization of phone calls. Because they're there in the home and they could do that together. Anytime that, as helping professionals, that you guys can, if the parent's willing to practice some of this stuff, to think about the skills that they're going to use before they get there and think about the things that might be upsetting to them and what they want to do and how they want to have kind of like at their fingertips a way to stay calm and kind of maintain that appropriate demeanor in the meeting. That's a place that I really think that helping professionals could be really useful in. And then I kind of already said this, but put everything in writing. Put everything in writing. Any request, concern, problem, any communication with the school, put it in writing. A lot of schools use communication notebooks. Those are great. If there's something in a communication notebook that's super important, you can take a picture of it and keep it on your phone, or the parent can. Um, that's just really important to have that documentation. All right. So let's kind of move into these processes. So eligibility for special education begins with a referral. It can come from different places. It can come from birth to 3. It can come from the student assistance team. A student assistance team is a team of people at the school level who might notice a student's having a rough time, and what they're supposed to do with student assistance team is consider non-special interventions that might be able to make the difference for that student to be successful. And I believe you have to do at least 2 SATs, and then you can consider special education testing. A parent can refer. They can request an evaluation by sending a letter to the county special ed director, and that person's information is usually located on the county's website. And then child find. So what child find is, schools have a responsibility to identify and evaluate students with disabilities who live in their attendance area. And so that puts a lot of responsibilities on schools to find those kids and serve those kids. Eligibility refers to the determination of disability. There's a three-prong question. Does he meet eligibility in one of the designated exceptionalities? Does the student experience adverse effects on educational performance? And do they need special education? So there's 14 areas of exceptionality. Most of these are things that you're going to know what that means. I am going to point out number 3, deaf blindness. That's a separate thing from deaf and blind. It's its own thing, and I'm going to tell you what that is. Deaf blindness is a distinct, low incident disability characterized by a combination of vision and hearing loss that significantly impacts functionings. It does not require a complete absence of both senses. Most individuals retain varying degrees of usable sight or hearing. Um, so those are the different areas that a person can be served under. And number 7, West Virginia does still have a gifted program for younger kids, and then they have exceptional gifted for kids who are disadvantaged in some way, who have that IQ of more than two, gifted an IQ of more than 2 standard deviations above the mean. And so for kids who have that, who are also homeless or who are free or reduced lunch or have other disabilities, they call that exceptional gifted. So evaluations are used to figure out if a student is eligible or not. There's a multidisciplinary evaluation team. They get together and they talk about what they think they need to assess. They send to the parent a notice of individual evaluation, reevaluation request. The parent should sign and send that back. When the school gets the form back, they have 80 days to complete the evaluation and hold the eligibility committee meeting. Usually eligibility committee and IEP meetings are held together, not always, they don't have to be, but all of that stuff is supposed to happen within 80 days. The notice of evaluation, reevaluation form should have marked everything that they're going to assess. Um, the assessment tools that are used should be tailored to the student. So pretty much, I imagine everyone's probably going to include an IQ test and academic achievement, but it would vary from there. It would, if a person might need speech language therapy, if they might need OT, PT, if they want to do a behavior scale, an autism scale, it's going to depend upon the student. And then every 3 years, you do it all again. There's a triennial reeval. And so the year before, the IEP team gets together, they make the new reevaluation form. It says everything they're going to assess, and it goes from there. They do it, and then they come back, and so on and so forth. Just a little bit more about eligibility and evaluations. Um, the team can request additional evaluations. Family can get an independent education evaluation that's paid for by the school system. A parent can also use evaluations that they had done privately, and the school has to consider those. But if the family had one done and they don't want to consider it, they don't have to bring it in. Um, After eligibility committee, the team has 30 days to develop the IEP. So LEA means local education agency, which is school, the school. 30 days to develop the IEP. And if the kid's not eligible, then there's certain steps that the parent can take. They have to get it, the school has to tell them in writing why they aren't eligible, and then there's steps that they can take. Questions so far?
I'm
Okay.
curious, Deb, and this is like so much information, it's amazing. Um, so if an individual is having trouble navigating the system, say they have an IEP, but they feel like their kids' needs aren't being met or the school isn't following the IEP, is is disability rights as an individual parent like a resource for them in general?
Yes.
They can just call you or call, not you specifically, but call someone and say, I don't know what to do, but I know that my kids' needs aren't being met.
Yes.
Okay.
Um,
Okay.
Probably first point them to the Parents Advocacy Guide, because we want people to do as much as they can for themselves. And if they're in kindergarten or first grade, they're going to be doing this for a while. And so if they can kind of get in, like I wish I would have read the PAG 4 years ago when I started here, because I learned a lot just preparing this presentation. which, by the way, I forgot to say that I have loved this Echo, and I'm really excited to be able to contribute something to the group because I've learned so much from being in it. Um, and I'm just really glad to be able to present to you guys today. Um, and so there's always a piece of families learning how to do that for themselves. And also they can be served through individual advocacy through a service request if it comes to that. And we have an amazing education advocate down in Charleston office, technically Cross Lanes. She is just amazing. Um, she knows this stuff from personal experience with one of her kids, and then from there, someone, have you heard about this person? She might be able to help you. And then she was on DD Council, and now she works for DRWV, and she's amazing. So, anything else before we go on? Okay. The IEP. The IEP is like the treatment plan for school. It should say everything that the kid needs and that they need to get to be able to fully participate in school the same as non-disabled students. Okay? Specialized special education is specially designed instruction at no cost to the parent to meet the unique needs of an eligible student. If it's not listed, if it's not on the IEP, the school doesn't have to do it. So if the school says they're going to do XYZ, if they don't put it in writing, they don't have to do it. I mean, they might just be good people and keep their word, but there's no legal responsibility. Like the IEP is like a legal document that school says they're going to do these things. So when do you have an IEP meeting? We already talked about 30 days within from the eligibility committee, at least once a year. If someone on the team, anyone on the team can request an IEP meeting. If so, it needs to be held within 21 days of the request, or the school sends out one of those prior written notices, which is again a really important piece of paper that says why or why not the school did or didn't do whatever. Um, we're going to talk about discipline. Hopefully, we'll get there. But if a student with an IEP has missed more, has is removed for more than 10 days, that constitutes a change of placement, which requires a IEP meeting. It also requires a manifestation determination review meeting. And we're going to hear more about that. But that 10 days is pretty important. So more information about the IEP. The parent should get 8 days notice ahead of time, written notice ahead of time to let them know when the meeting is. They are not allowed to say we're having a meeting tomorrow and you have to be there. That's not allowed. They're actually really for real supposed to coordinate with the family to think of a date and a time that works and is convenient. It's really important here that the parent communicate and participate as much as they possibly can. If they can't physically be there, nowadays we've got really cool things like Zoom or participating by phone. Um, and even like, I don't know, I will find out is going to be so much better for the kid and the parent than like crickets. Any type of communication with the school is good. Um, the purpose of an IEP meeting, there's different reasons to have an IEP meeting. Um, you can have a targeted review, which is when you're just reviewing like one specific part of it. Um, they have to have, oh, I'm on the wrong thing. My bad. Da, 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 da. Okay, so the reasons are to develop an IEP or have an annual review, to discuss transition services, to develop the triennial reevaluation determination plan, to talk about the transfer of students' rights at age 18, to conduct a manifestation determination review. There's probably others as well. For a IEP meeting, the school has to say who they're inviting. They have to put it on the form that they send to the parent that says when the meeting's going to be. The parent can pretty much bring whoever they want to, but it's nice to tell the school who they're bringing. You can bring your preacher, you can bring your hairdresser, you can bring your sister, whatever. But it's nice to let the school know. The people who are required are a parent, a general ed teacher, a special ed teacher, and someone who works for the school system who has the capacity and the responsibility to allocate resources. So someone who gets to make money decisions, right? Usually the principal, sometimes the special ed director. A lot of times when I go in for meetings, especially if they're like behavioral stuff, there's like 10 people sitting around the room and the parent. And you've got a principal, an assistant principal, a counselor, a social worker, a school psychologist, another person from the county, the special ed director, plus the general ed and the special ed teacher. Um, so if the parent has someone that's a good person to bring with them, who's going to be supportive and also able to maintain composure and all of those things, really recommend that. And also, it's kind of like when you get bad news from your doctor, there's like so much information. It takes two people to take it in. It's kind of like that too, that there's just so much information going around the room. Um, it might be good for the parent to have another set of ears. Okay, the student may be invited, um, if it's appropriate, but they have to be invited once they get to age 14 to talk about post-secondary goals and transition services. Um, Parent participation is really important. Anything that you guys can do to help them prepare ahead of time with like questions, concerns, specific things, any positive comments they want to give. I really appreciate the way that the bus driver made sure that my kids' shoes were tied or whatever. Like anything positive that they can come in with as a thing to start with is always good. Um, Student participation, kind of the same way. If you're working with a kid who's going to go to their IEP meeting, working on identifying facts about what is or is not happening and how that affects their educational experience, what they would like more of, what they would like less of, and trying to, again, maintain composure and have an effective meeting. Okay, so there's a bunch of different parts of the IEP, and I'm gonna kind of highlight the ones that I feel like are really, really important. Okay. So, part one, name, date, address. Part two, everybody signs they were there. Extended school year for every kid loses some information over the summer. Um, Kids with disabilities do so more, and there's a way to test for that and see if a family need or if a kid needs extended school year. Well, let me talk about considerations of factors for IEP development. This is a really important form. There's a bunch of different things on there that talk about what a person needs. And so this should track. So some of the things on there are, do they need a communication device? Does behavior impede their learning or the learning of others? There's other things, but I'm really going to focus on that behavior impedes learning or learning of others. If that is checked, when you get over here to part 7, present levels, the present level should talk about whatever was marked on the consideration of factors that should be commented on in the present level. So kid needs assistive technology. Present level should talk about what the technology is, how it's working for them, um, any kind of information about that. Same for behavior. If it's on consideration of factors, there should be information, behavioral information, like described behaviorally is what I mean, in the present levels that talks about intensity, frequency, duration, what they do, what it looks like, the thing is that they do that they consider problematic, how that affects their learning, how that affects the learning of others. And generally, present levels should be a description of everything that the kid is doing currently. And it should have numbers data, like they're reading uh, consonant vowel. This is old school stuff, but consonant vowel consonant at 90% accuracy. They're answering simple comprehension questions 3 out of 5. They're answering complex reading comprehension questions at 0 out of 5 or whatever it is. That's really important because when you get to your annual goals, the things that are mentioned in the present levels should also be mentioned in the annual goals. And that's how you get a behavior to manifest as a disability, is that it's in the present levels. No, wrong. It's on the consideration of factors. It's in the present levels. There's a goal for it in the plan, and there's services for that. When all of those things are in place, then it's more likely that a behavior is going to manifest as a aspect of their disability as opposed to just bad behavior. There's other things on here. There's our good old prior written notice again. That's a really important piece of paper. It says everything that they're going to do or not do and why. Services is kind of just adding up stuff, but services also gives you a good picture of participation in special ed versus general ed. And if you get to the end there and you realize that that participation in general ed number is lower than you expected, that's a time to go back and look. When the parent walks out of the school, they should have a completed copy of the IEP and any other forms that they talked about while they were there. That's important. They've been sitting there maybe for an hour and a half. Maybe they want to tell the school, hey, I'm going to go out to my car and get a bottle of water, or I'm going to take a bathroom break. If they need to get out of that room, if they can't sit in that room anymore and wait for 10 minutes to make copies, cool, let the school know that they're just going to take a break. I've seen meetings go reasonably well, and then in that 10 minutes, the parent, like one in particular, she started talking trash on a whole bunch of people. She was throwing F-bombs around. It went really bad from like a not so bad meeting, and then she just like really, that's going to affect how the school looks at her long term. And it is so important. I don't think it should, but it is so important the way the school thinks about a kid and their family in terms of how patient they're going to be, in terms of how accepting they're going to be, how willing they're going to be to try different things. Um, I did a side by side of the IEP and the 504 plan. Um, an IEP is like a higher level of care than a 504 plan. They kind of started at the same places, but they ended up in different places. And a person who's tested for special ed who doesn't qualify may still qualify for accommodations under 504. Okay, so let's get to some of the really juicy, interesting stuff. For families who move around a lot, or if the kid's being moved from school to school for whatever reason. So I'm kind of thinking about kids in care. If it's an in-state school, the school is supposed to consult with the parents or the grown-ups in charge of the kid within 2 days, and they have to initiate free appropriate public education within 1 day of the parent consultation. So free appropriate public education, that's FAPE, and they have to get that started. Then we also have a thing called the stay put principle. I don't think that actually made it into the slideshow, but the stay put principle is when there's a question, the thing that's in place stays until the question's resolved. So if a kid comes in with an IEP, before you can do the other stuff to change the IEP, that IEP is the IEP that you're working from. I know when I was a teacher, I had a kid transfer in, and I had a resource room, which meant that kids came and went from my room for short, like 30-minute, 45-minute instruction. Then I went to classrooms for collaborative stuff. We had a kid come in who had an IDD diagnosis and who had like many, many hours every day in the resource room. And I remember us trying to scramble to figure out how we're going to meet that IEP until we can get a new IEP written to serve her with the amount of time that she was supposed to be served. And so basically I had a kid, by my side all day, every day for about a week before we got that figured out. Within 10 days, the school has to develop a new IEP. If the kid's coming from out of state, the school has to consult with the parent within 2 days. They have to initiate FAPE with services comparable to the previous IEP. And within 2 days of enrolling, the receiving school request records. And then McKinney-Vento Homeless Assistance Act has a special rule for students experiencing homelessness in terms of what they have to be able to produce to enroll and to get records to come. And McKinney-Vento, you guys are probably familiar with it, has a really liberal definition of homeless. So living with another family, living in a hotel, living in a car, all of those things are considered homeless, even though the family's sheltered for the purposes of McKinney-Vento, that's homeless. All right. So when I started doing this presentation, I thought that I was going to find a whole bunch of different stuff about what's supposed to happen for kids who are in care. I was wrong. The rules are all the same. The rules, policy, procedures are the same eligibility, same requirements on the IEP, same protections around behavior, manifestations of disability, still required to provide special ed minutes, accommodations on the service page. All that stuff is supposed to be the same. I was really surprised to learn that because one of the things I do a lot of is monitoring, which means I go to different places, any place a person with a disability might live, work, learn, play, or vote, and see what goes on there. And the schools function really differently from schools out in the community. So I was really surprised about that. I want to tell you about an educational surrogate, though, because there is some misunderstandings about that. The school has a responsibility to make good faith efforts to locate a parent and maintain records of these attempts. When a natural parent is available but chooses not to participate, the district cannot appoint a surrogate parent. If they have parents who just aren't there, it's not appropriate to use a surrogate parent. Bio parents maintain educational rights until parental rights are terminated or unless the MDT or court says they aren't allowed to participate for some reason. Um, I don't think a lot of people know that. When I was a worker, I didn't know that. I, having come from my special ed background, was a worker and I was the guardian of that kid. And so I thought that I was supposed to sign the IEP and I was never told otherwise. And so that's what I did. And now I know better. But a lot of people don't kind of get the nuances around a surrogate. So if a parent's being cut out, if they're allowed to participate in the school stuff and they're not being included, that is important. And they probably need some assistance around that. There's criteria for who the surrogate's supposed to be. It's not supposed to be anybody who has any kind of relationship with the school staff. Some additional information that comes from foster care policy. The state is responsible for reasonable travel for the child to remain in the school from where they were enrolled at the time of removal, if that's feasible. There should be no time lapses due to the transfer of schools when a kid goes from place to place in care. School personnel should be invited to all MDT meetings. The caseworker should send the notice to the school the kid did attend, is attending, or will attend. And finally, DOHS worker visits should not interrupt the child's school day. They shouldn't be done at school. They shouldn't interrupt the school day. They shouldn't miss school to meet with their worker. Discipline. So I talked a little bit before about that 10 days, up to 10 days. After 10 days for a disciplinary removal, that becomes a change of placement. And when you get to that 10 days, a whole bunch of stuff happens. You have to have an IEP meeting. You have to have a manifestation determination review. There's going to be a disciplinary action review form. The student is supposed to be able to get their educational services despite whatever else is going on related to their behavior that's related to their disability. Now, if it's a behavior involving weapons, drugs, serious bodily injury, whether or not it is a manifestation of a disability. So those like really critical behaviors, this manifestation determination thing is not going to help, unfortunately. Um, when they do the manifestation determination, they should also be either doing a functional behavioral assessment or reviewing the one that they already have. Same for developing a positive behavior support plan or reviewing the one that they already have. Those are supposed to be done by people who know how to do them. It's good for parents to inquire who's doing them and what their credentials are. And if they don't think, if it doesn't seem like a quality document, definitely ask more questions and get more input. And this is another place where a helping professional may be able to help if they're working with the kid to help understand the kid's behavior and what's going on and possible reasons. You know, a functional behavioral assessment is supposed to talk about the function of the behavior. Like everybody does stuff for a reason, and that's what that's supposed to talk about. But when I read them and they say, the kid is, we hypothesize the function of this behavior is to get something the kid wants or to get out of something he doesn't want. It's like, well, duh, that's why everybody does everything, right? To get what you want, to get out of what you don't want, or not lose what you have. So I personally wish that they would work a little harder on those hypotheses. All right, bullying and harassment. This information comes from PACER's National Bullying Prevention Center. It defines bullying. It may be considered harassment when it's based on certain things, including disability, and the schools are responsible for ensuring a safe environment. If there's bullying and harassment going on at school, the school has to respond with an investigation. And there's things that can be done in the IEP to help prevent or address bullying or harassment. But steps that are taken to address harassment shouldn't penalize the person who is being harassed. So if someone's schedule needs changed It shouldn't be the kid who was getting beat up. It should be the kid who was doing the beating. If the school doesn't respond, the parent can file a complaint with the school or with the Office of Civil Rights. And last one, what to do if the parent and the school don't agree. Again, put everything in writing, everything in writing. Any requests, any questions, anything, put it in writing. So one option is to work out disagreements is a facilitated IEP meeting. And that can be voluntary unless it's ordered by a state complaint. Oh, sorry, by a state complaint mediation or due process. It's facilitated by a third party to guide the IEP process and promote communication. Depending upon how that goes, a state complaint can be filed within 1 year of the incident. Must be done in writing with an original signature, and again, the person should keep a copy. The State Department has 60 days to investigate and issue a written decision if there's a complaint filed. Within 15 days of the filing a state complaint, the parent and the school could come to an early resolution if they want to. If early resolution is reached and the school doesn't follow through, a new state complaint must be written and the timelines start all over again. Now, the reason the special ed director kind of has her own has their own bullet point is if they were not at the IEP meeting, it puts another layer of, or another task in the task of things to do. The parent should write a letter to the special ed director explaining what they requested that the school is refusing to do, why they want it for their child, and ask the special ed director to respond in writing within 10 school days. And if the special ed director won't help, then go to the state complaint. It's just like you kind of got to inform that person. And actually, I think I have a boo-boo on my last two boxes. They should actually say mediation and due process hearing. So mediation is an option if there's conflict. Both parties have to be willing to give and take, and agreement reached by mediation is legally binding. And then the final option is to file a due process hearing request. If a parent files a due process hearing request, they have to prove that they are correct. And I'm going to reiterate, if a parent wants to get an attorney, it's better to secure the attorney, obtain the attorney before filing, just because it's hard to find an attorney and it takes time. Hearing requests can be filed within 2 years of whatever the conflict occurred, and the school has to reply within 10 days. So that is a super quick down and dirty on special ed for helping professionals. What kinds of questions do you guys have?
Deb, I don't have a question. I just have some